Hello, my name's Professor Brett Davies. I'm a barrister and solicitor at Legal Consolidated. I lecture the estate planning unit at a number of universities around Australia, and today we're going to do a training course on estate planning, and in particular wills and three-generation testamentary trusts, bankruptcy trusts and maintenance trusts, and also the dreaded superannuation testamentary trusts to wash out that 32 or 17% tax on non-dependency. So let us begin. The first thing we're going to do is we're going to our law firm's website, and we're the only law firm in Australia providing legal documents online. All other websites are not law firms. I'm going to go to estate planning. Now there's a number of different types of documents that your clients will need. So this training video is predominantly for financial advisors, accountants and lawyers. So we're going to do wills today, but there's also enduring powers of attorneys from dad to mum, from mum to dad. Also medical powers of attorneys, again, one from dad to mum and mum to dad, maybe the children as backups. They're the three main documents that you will need to prepare for each of your clients. So you need to have those documents, and you can build them all on our website. And when you do, we are providing the legal advice. You can provide your accounting advice, your financial planning advice, will provide the legal advice and the legal documents. There are also some additional documents which are very popular, and that's a contractual will agreement. That's when you are getting married, your clients are getting married to a second person, so there's children from one relationship and children from the other spouse. And when you do the will, this is an agreement not to change the will. The second one is a codicil. So if you've got yourself a public trustee will and your client's happy with it, you just got to remove the public trustee, which is always a wise idea. The public trustee charges money to administer the estate when your own family can do it with the help of your advisor and accountant. Remember this, the public trustee charges a lot of money to administer an estate, therefore they give away free wills in the hope they'll get some money. There's also some lawyers out there in the marketplace in Australia which like to make themselves executors, and I think that's a little bit naughty of them because they then get to charge fees. That codicil can just keep the will going but change the executors. Forgive a debt agreement. Now this is when someone, for example, you owe money to the family trust, or the family trust say owes money to you. That's very common. Family trust will make a distribution to you. You will never pay it. The family trust will never pay it back. That's called an unpaid present entitlement, and in which case you can just forgive it every year. So you do a deed of forgive a debt agreement. Now, if I was to die, I have a lot of distributions to my family trust each year. I love my family trust. However, I will forgive the debt. The family trust, or I will forgive the debt. So I will say to the family trust, you no longer owe me the unpaid present entitlement. You no longer owe me any money. So if I was to die or go bankrupt, the family trust wouldn't have to fork out the money. If I don't get rid of these UPEs, I then die, those debts owing by the family trust are assets of my estate. If I go bankrupt, the first thing the trustee in bankruptcy will do is say, does the family trust owe Brett Davies any money? In which case they'll collect it. So forgive your debt. Get your clients doing a deed of debt forgiveness every year. Obviously for the spouse it doesn't make much difference if he or she is not working, they're at low risk of insolvency. And also for children. Now the children under 18 just write off the debt because you only make a very small distribution to them, and every time you give them a Christmas present. But if they're over 18, you also do another deed of debt forgiveness for them and get the children each year to sign the same deed of debt forgiveness. A deed of gift is when you've dad has actually given some money to his mistress or to his son, and he then dies and the estate says that wasn't a gift, that was a loan. Deed of gift makes sure that it is actually a gift, so it doesn't have to be repaid. Then the last two documents are loans. So again, I'm a high risk of bankruptcy because I'm a lawyer and I give legal advice. If you're an engineer and you give engineering advice, you're high risk of bankruptcy. You're a doctor, you're high risk of bankruptcy. You're running a building site, you're high risk of bankruptcy. So all those sorts of people, if they were to get some money from the family, like from their wife, the wife would lend them the money. So if they were to go bankrupt, the wife would then try and get some of the money back. And again, loans to children, critical that you do not give money to children. You lend them money, because if those children then get divorced, you get it all back. So let's say you make a distribution of $150,000 to your son, he gets married, he then gets divorced, half of that $150,000 will go to his wife, his ex-wife, but if it was a loan, you get 100% of it back. But today we're going to do last will and testaments. There are 4 major types of wills in Australia. I'm going to take you through the 4 of them. The first and most common are mutual wills, mutual will with tax planning, and mutual will without tax planning. Now, the mutual will with tax planning contains 3-generation testamentary trusts, it contains bankruptcy trusts, superannuation testamentary trusts, and all those other tax-saving mechanisms. In a mutual will, you leave everything to mum, and dad leaves everything to his wife. So they are giving assets to each other in the first instance. So in my case, I die, everything goes to my wife. But if she dies first, everything goes to me. Then once we both die, everything goes equally to our children. That's the classic mutual will. Now, if your client's not leaving everything to his spouse, then you wouldn't do a mutual will, you'd do a single will. You do 2 single wills. The mutual will here is, again, to dad, to mum, then to the children equally, but it has no tax planning. And then there are single wills, 2 types of single wills. One's tax effective and one is just a simple will. The single will is maybe the mum and dad, mum's husband's dead, so mum just leaves everything to children equally. Dad hasn't, the person making the will was not yet married, so they just leave everything to their mum and dad. There are training videos on each of those documents here. There's also an overall training video of which will is best for you. But let us now start building the most sold mutual will on our website, which are 3-generational testamentary trust mutual wills. Now, this is the same thing you'll see on every one of the hundreds of different documents you can build on our website. There is a checklist, so you can see the type of questions that will be asked, and you can actually print that off and get the clients to complete that. There's also a full sample of every single one of our documents. Every single one of our documents has a full sample which you can look at. And there's the will there. That's interesting, the logo. Now, if you wish, you can actually put on your accountant, financial planning or legal logo in your My Records section, and then you get an option. Every single document you build, you can either put your logo on or leave it off as you see fit. So there's 2 wills, mutual wills, so there's 2 wills. There's the appointals. Now, obviously, when you build documents for your clients, they'll look different because they might have a different age of majority, they might have 6 children. That's the husband, that's the wife's will in this instance, in this example. And then we're going to go to the husband's will. Again, your logo could go there if you did want to put it there. And then we're going to go to the very end. And what will we find? We'll always find the same document, which is a letter of advice from our law firm confirming that we own the document, we're responsible for it, not you as the accountant or the financial advisor. And it's signed by a partner of our law firm. In this case, I signed the estate planning documents, and there's me. So you've actually got a law firm's letter stating that we built the document, we own the document. There's more information there, yet again some training videos, but let us start now building our 3-generation testamentary trust mutual wills. Now, when you join up, just check with your accounting house or financial planning house. Try and use the same username and login each time, because we've got some accountants with 400 or 500 documents, and you want to build them all at the same location. So you can come back in 20 years' time and think, did I build wills for Mr. and Mrs. Smith 20 years ago? And you can go in and see all the documents you've ever built. So it's always better to not each accountant have their own login. It's better to have one login for the accounting house. Now the other useful thing is that if I was building Thomas's wills, I could actually select that client Thomas's, and all his data will go into this mutual will. But in this instance, I haven't built a document for them before, so I'm just going to start it from fresh. And there's your layout. These are the questions that are going to be asked about you, your spouse, assets in alias names, contemplation of marriage, a reference page, a summary, and then we'll be asked to buy the document. It sounds pretty good. I'm going to put in the data. So my client's name is Thomas James and his date of birth. Second of November. 1 George Street. Now, I have over here many different types of hints. So let's have a look. What about, am I building two wills? So this is going to take you through the concept of a mutual will. They're mirror wills. They're everything to each other. Everything to each other first instance. So you don't actually have to put anything in. Once you put you and your spouse in, everything goes to each other. Well, what about the Superannuation Testamentary Trusts? Explains how they work, how they will seek to wash out with 17% and 32% tax to your adult children. See, there are four death duties, predominantly in Australia. There is income tax, stamp duty, capital gains tax, and the 17 or 32% tax on your super when you die. These wills will seek to wash out all of those taxes for up to 80 years from the date of your death. There are two opportunities to tax plan. One is at divorce, when you break up with your spouse, but everyone hates everyone at that stage, so very rarely do you have the tax savings as your main mechanism, which upsets many financial advisors and accountants and upsets me as well as a tax lawyer. The other best time to tax plan is at death, and this is the will to do it. This is the 3-generation testamentary trust. This is the ultimate degree of flexibility, and if you have to narrow estate planning down to one word, it's flexibility. We have 3 great uncertainties. We don't know when your client will die. We don't know what assets they will own. It's highly likely your client only assets will be cash at bank. As they get older and they get frail or infirm or suffer Alzheimer's, their assets will be sold down by the children. You move the client into a retirement home. They no longer can get the principal place exemption on their family home after a number of years, 6 years or whatever the rules are in that particular instance. There's now land tax on that property, so it might be better to start liquidating the position. So often clients die with cash at bank only. The third great uncertainty is we don't know what the tax laws will be. So we don't know when you're going to die, we don't know what you're going to own, and we don't know what the tax laws will be. How exciting opportunities can come from that. So we've got to stay flexible, and estate planning is all about flexibility, and the 3-generation testamentary trust that automatically goes into this particular will is the best way of producing flexibility for you and your clients. So with the Superannuation Testamentary Trust, if superannuation goes into the will, it's then dealt with in a way to wash out the non-dependency tax by having a test individual. Remember, the test individual for a taxation dependent, there's 2 definitions of dependence. One is under the SIS or the superannuation laws, the other one's under the Tax Act. I'm only interested in the Tax Act at this instance. Under the Tax Act, unless you are the spouse, a child under 18, have a financial dependency or interdependency, if you don't get under any of those 4 umbrellas, then there will be, for the concessional contribution in your super, that's when you put it in pre-tax, generally there will be a 17 or 32% tax. But if you have a superannuation testamentary trust and the super gets into the will, you've got high opportunity of washing that tax down to 0. So the test individual is at the test period is at the exact moment of your death, at your client's death, was there a dependent? And we have had a 100% success rate in showing a dependency, an interdependency relationship with financial dependency. And give me a telephone call if you want to discuss those issues. We've never ever lost on one. Now, with the money going in, the capital is protected for the test individual the next 80 years, but the income is then dealt with by your children who distribute the income as they see fit. The capital is also not protected. So that's Superannuation Testamentary Trust. To the tax man I leave. So here are the other three types of death duties. Income tax stamp duty, it takes you through that. Will the tax man smile when I die? No, the tax man will not smile because you as the accountant and financial advisor have bothered to make sure there's tax effective planning in for your clients. The government has made a will for you. Now, a lot of men particularly do not want to test fate and make themselves a will. Because they make themselves a will, it means they may die. Well, that's not true, but in any event, the government has already made your will. So if you live in Queensland, you've already got yourself a Queensland will when you die. Every state and territory has put together a statutory will. And the will may not go to the places you want it to go, but I'll tell you one thing for certain. One of the main beneficiaries of a government-made will is the tax office. There is no tax planning. So you want to think very carefully about allowing your clients to get a statutory will. Now, you know, you've got clients who have been coming in for 12 years now. They come in, they say, oh, look, have you seen Brett Davies to do your estate planning? Oh, no, I haven't. 12 consecutive years. Well, you frog march them into your secretary's office, you sit them down, and you build this will on the website for mum and dad. Get them a will. Get them a 3-generational testamentary trust will. Now, I'm happily married. That's good because this is the exact document. If you have a spouse and you're leaving everything and she's leaving everything to you, then everything to the kids or to a group of friends, this is the exact document you need. Who's the trustee in my testamentary trusts? Now, remember one thing, the testamentary trusts are only to do one thing and one thing only. They reduce tax. If you're in a bankruptcy trust or spendthrift trust, well, we can do those, and we'll do those in the will later on. But the testamentary trust is only designed to do one thing. And you've got to be very careful explaining this. I need to be very careful explaining this. The testamentary trust just saves money, saves tax. It doesn't stop spendthrift children. It doesn't stop a family court taking the money and giving it to your ex-daughter-in-law. It just saves tax. The trustees of the testamentary trust, who are they? I don't know. You'd need to ask your 3 children. If you're living with your 3 children, they'll make the decision as to who the trustees will be of their testamentary trusts. Now, 3-generation testamentary trusts have a unique strategy of being discretionary of nature, which means that you can actually not set up a testamentary trust, or you can set up testamentary trust, or you can set up many testamentary trusts. So let me take you through a situation we had in our law firm. We had mum and dad died, and we had 3 children come in. The 3 sons came in. After they come in with their accountants and advisors, as they should do, as our 3-generation testamentary trust will state, you should come in with your accountant and advisor, because most of estate planning is to do with financial planning and accounting, not law. Not law. It's to do with the structuring of your financial affairs. And that's why the proportion of costs and work relating to estate planning is very small for the lawyer, but very high for the accountant and financial advisor, because you're doing most of the work. So let's have a look at these 3 boys that turned up in our boardroom with their accountants and advisors. Their parents decided to leave everything, they both died, and left everything equally to the 3 children. After about half an hour of going through the tax strategies and how we can really go to town and save income tax, one of the children just got up. He didn't come in with his accountant and lawyer, and he said, Dr. Davies, with respect, I don't care, just, quote unquote, cut me a cheque for 1/3 of the assets. And he just left. The second child he was on maternity leave. I'm not quite sure how a man can be on maternity leave, but he's on maternity leave. His accountant set up one testamentary trust, which he'll probably keep going for about 8 or 9 years, and then the accountant said it probably won't have much need for it after that. The third child set up 3 testamentary trusts out of the same will. 3 testamentary trusts, just for his 1/3 of the assets. Now what he did, he took the father's 2 businesses. And this is another beautiful thing about 3-generation testamentary trusts. One child can take cash, one can take shares, one can take the family home, another can take the business. So you don't, as long as you're dividing it up equally, 50-50 or third, or quarter, providing you do that, you can actually manipulate the assets so one can get shares and one can get cash. That's a distinct advantage of a 3-generation testamentary trust. Otherwise, you're going to have half the shares, you're going to have half the property. That's ridiculous. Do a 3-generation testamentary trust. The third child set up 3 testamentary trusts under the advice of his accountant. One for one business, because businesses are high risk. So if a business goes down, it contaminates everything in the family or testamentary trust. So he set up 2 testamentary trusts, one for each business, and the third with all the other assets that he got from the rest of his 1/3 went into the 3rd testamentary trust. So this is beautiful flexibility, and we love the word flexibility. It's the number one thing that we aim for. So the trustees of testamentary trusts, well, talk to your children. They'll make the decision. Normally, or they will be the trustees of the testamentary trust, but the accountant for asset protection may want to put in a company, in which case we did in those 2, in that 3rd son, 2 of the testamentary trusts had companies because of the asset protection advantages. Does my will automatically contain 3-generation testamentary trust? Yes, it will. Sample of the document, you've already seen it. Advantages of dealing with a law firm. So you are on a law firm's website. If you ring us up, if you chat with us here, all you do is you talk to a lawyer. There's no computer programmers here. Natalie, there's no computer programmers here, are there? No. We're just all lawyers. So ring us up and you'll speak to a lawyer, and that gives you the protection of professional indemnity insurance, legal professional privilege. These are all advantages that only a law firm can give you. Plus you get a letter on our law firm's letterhead for every document, and every time you ring us up, you get legal advice. We don't tell you to go off and ring up a law firm. We are the law firm. So we've got Dad. There's Dad. He's in. Now, the next question will be the spouse. So this is not, now I'm talking about a married couple of a husband and wife, but it could be a de facto couple, it could be a same-sex de facto couple, and it could be a married couple, a same-sex married couple. It doesn't make any difference. You are you and your spouse is your spouse. So if John is married to Jeff, then there's John there and there's Jeff there. But let's now look at the spouse. Notice I've got a green tick there. Green ticks means that we've checked, our law firms checked the logic, and we are happy for you happy with that question, the answer of that question. So, Mary Davies. And she lives in St Kilda. And you can see some of the questions there. So for example, I'm not married. This again deals with de facto relationships, no different. But there's a little training video there. And why are there mirror wills? So again, we are leaving everything to each other. Lots of training videos, lots of help. Let's make a mistake here. Let's leave off the surname. There's a mandatory box there, but I don't care. I'm going to press next. Aha, it will not go forward. I've not got a green box on this. So the logic flow is very tight. And it has to be. Our law firm carries millions of dollars of professional indemnity insurance on this document, every single document we build. So we need to make sure there's tight logic. So I have to put in a surname. Davies. And I've got my green tick. The law firm's happy, so I'm going to move to next. Now, some people have assets which are not in their names. So for example, Thomas James may have an asset in another name. He might go with Tom, in which case he'll write Tom Davies there, or Tom, what's his surname? Tom James. In this instance, he doesn't. But quite often a wife or spouse may have assets in her maiden name, in which case you put a maiden name there. So, Mary Smith. So there we've got the alias. And all we're going to see in the will when we build it is also brackets, also known as Mary Smith. Now, these are the backup executors, but hang on, I haven't put my initial executors in. Yes, you have. Because if you had read the hint on mutual wills, it says that you leave everything to your spouse and make your spouse the executor. But if your wife dies, she leaves everything to you and makes you the executor. So the initial executors are each of you. But once you both have died, or perhaps when you die, your wife's too frail or of unsound mind, then the backup executors come in. And I've got 2 children, so I'm going to put my 2 children in as the executors. Now, my children are already over 18 or 21 or whatever age you want, so I'm going to leave that blank. So there's no age requirement there. There's lots of hints here. Who are the best backup executors? Now, this is an interesting question because if you speak to some lawyers, they'll say that the lawyer is the best executor. They kind of have a bit of a bias there, and lawyers shouldn't really work with biases, but a lawyer will say that he's the best, or he or she's the best executor, but the lawyer makes fees or gets money out of being the administrator, being the executor. There's another group of people called public trustee, and the public trustee also says it's the best and safest course of action. Be very careful, the public trustee make money out of being your administrator. There's also a lot of professional trustee companies. They would love to also give you a free will and make themselves the executors and charge potentially tens of thousands of dollars for administering your estate, which you and your wife can do for free, and then your children can do it for free. Now, if your children don't want to be the executors of the estate, they can always hand it over to the public trustee. But I've never known them to ever do that. I've been practicing in this area since 1988. I've never known a person want to waste money by giving it to the public trustee. Now, the public trustee go, oh, Professor Davies, we really need to think about that because you've got to do tax returns. We have to do, the clients have to do tax returns. Well, Mr. Public Trustee, they just get their accountant to do tax returns. We don't need your accountant doing it. They've got their own accountants, or they can use their parents' accountants. Oh, but adjunct Professor Dr. Davies, but what about financial planning? They need financial planning advice. But Mr. Public Trustee, they just go to the financial advisor and get it, and they can hire and fire their financial advisor. They make you the trustee. They can't sack you. And you've got your own bank accounts. You put money into your own bank accounts. No, we don't want that. We want to give power back to the people. We want to stop the control of a government instrumentality, the public trustee, having control of our family affairs. The last person I'd want to give control of administering my estate to was the government. To all the taxes I've already paid. There's the article on that. Now, what about future children? If you have future children, just ring us up and we'll give you a voucher to do a brand new will, because there's 100% money back guarantee on all our documents. So if you have another child, ring up, email your old tax invoice, and we'll send you a new one to do a new will. And use the same data you've already got, so you just need to add the extra child. Now, what about children under, let's say 18 years of age, they're under 18 years of age, in which case, let's say my 2 children, Colin and Muriel, were under 18, or potentially under 18 at the time of my death, then I would appoint a 3rd executor, and it would be an uncle or an aunt or even my parents to do that job until the children become of 18. And then once the children are 18 or 21, whatever date you want to put in, then that executor can just renounce and not do the job. How many backup appointers can you have? If you've got 6 children, appoint all 6 children as your executors. Oh, but hang on, what if the children all hate each other? Appoint all 6 children as the executors. Obviously, if you love one child over another, and you hate the other children, just appoint the children you love. No, I'm just joking. I know you don't hate your, I know your clients don't hate your children. Appoint all 6. What will happen is that they'll all be honoured and proud that mum and dad have loved them enough and trusted them enough to be executors, and probably only find 1 or 2 will do it. The other 4 would just renounce. But appoint them all. It's not good just to appoint a couple. If they hate each other and fight together, that's better they fight at executor level rather than beneficiary level. Now remember this, there's a lot of misunderstanding as to the role of executors. The role of the executor is to carry out the wishes in the will for the best interest of the beneficiaries. Let me say that again. For the best interest of the beneficiaries. Now, in order to act in the children's best interest or the beneficiary's best interest, the executor has to obey the rules and direction of the beneficiaries. The executor is a servant, actually a slave, they don't even get paid, is a servant or slave of the beneficiaries. And therefore it's better that the executors fight at executor level rather than at beneficiary level. So my advice is better appoint them all as executors. They all hate each other, it doesn't make any difference. But let's, for a minute, make me the executor. I'm a very smart lawyer, so let's make Professor Davies the executor. And I've got the will, I open it up, and I'm saying, look, I'm sorry about your mum and dad dying, now I'd like to read the will. One of the children puts his hands up and says, Dr. Davies, I'm challenging the will. Oh, good, thanks for letting me know. I'll close the will up, I'll put it back in safe custody, let me know how the court case goes in 3 years' time. Because I can't do anything, I'm just the executor, I'm the servant. If these kids are going to challenge the will, I can't, I'm not some sort of big brother or some controller, I'm the servant. I'm the servant of the beneficiaries. So make all the executors beneficiary. You've got 6 of them, do it all. It makes no difference. To the validity of the will, you should do all executors. So I've got Colin in. It's in beautiful North Terrace. And now I'm going to put in a second, I've already pressed the button to appoint a second executor. He will be my second child, Muriel. May Davies. There we go. And lots of hints there. And I'm happy to leave that just as 18. In Hobart, Kings Meadows in Tasmania. So I'm happy with that. Now, Muriel she's bipolar and she has an issue with finance. It doesn't happen very often, but every 3 or 4 years she potentially will give away any asset she has at the time. I'm still going to make her the executor, but when I make her the residuary beneficiary, I'm going to dial her age up to 99 years of age so that her brother and her will be in control of those trusts for the next 80 years, the date of death. Obviously my boy, Colin's already got his half and he's gone. But with Muriel, I'm going to dial up, I'm going to increase the age of majority to 99 years of age. So she'll get the money, but only be drip fed over a 99-year period. Maybe I want to add another backup executor, so I might, if the children were younger, I'd add them there. So I'll put Uncle Harry. Harry Bus. But I've decided not to do that. So I'm just going to press next and see what happens. Won't go ahead because I haven't completed Harry's details, so I don't need it. I'm just going to press delete. Well done. So I've got the 2 children. Let's now move to the next question. Did I get a green tick? Yes, I've got a green tick. I'm doing well. Now, the age of majority is the general age of majority for everyone. We're going to override that for my daughter. I'm going to make that 99 years of age, but I don't do it here. I just leave it at 18. You think 21's better? Okay, we'll make it 21. Let's make it 17. What happens? Oh, can't make it 17. The youngest age of majority that you can have under Australian law is 18. But I can go higher. I can go to 21 in this instance, which is quite common, 18, 21, sometimes 25. My father said you don't reach maturity till you're 50, but now I'm 50, he said 60 before a man reaches maturity. So it's all in the eye of the beholder. All our children are old enough already, that's true, but if one of your children dies, what they would have got will go to their own children, who might well be 6-month-old babies. So that age of majority is important, even though your children will probably be in their 60s when you die. We're happy with 18, but one of a child is a spendthrift. Well, we'll deal with that. We've got Muriel, who's a spendthrift, and we'll be certainly increasing her age of majority to 99, but this is not the point for it. Who are the trustees of my children under the age of majority? Well, we would have put Uncle Harry in, but they are over the age. Do we just make the age of control 18? In my will, I did, but some people go to 21, 25, or even 30. There's going to be maintenance clauses in the will, so even though the grandchild may be under 18 or 6 months old, they can still be drip-fed money for their education, for living accommodation, expenses, even a holiday. My child is mentally disabled, then we would have died. If my child was mentally disabled, we probably would not have made them an executor. We would have made them a beneficiary at 99 years of age, but we probably would not have made them executors. But in my case, my daughter is bipolar. She functions beautifully well. She's a doctor, but she is unable to look after money at some point every 3 or 4 years. So I've made her the executor with my son. We don't have any children. That's fine. In which case, the children is just a generic name for this question. If you're leaving everything to, let's say you're a gay partner, same-sex partner, and you have no children, then you might well leave it back to your parents, half to your parents, half to your spouse's parents. Or you might decide to leave money to charity or friends. That's fine. But you do need some backup executors. So 21, age of majority. I'm now going to go to the next question, which is, look at those green ticks, which are specific gifts. I hate specific gifts. You should always press no to this. But Dr. Davies, we've got this beautiful car and I want to give it to my son and I want to give... Don't worry about it. The kids will work it out. It's highly likely when your clients die, they'll only have cash at bank. Most people die with just cash at bank if they live a good and wholesome life. So don't start doing specific gifts. Because, well, okay, you want to consider specific gifts? Let's talk about that for a minute. I had a client that left an $80,000 Jaguar V12, beautiful brown Jaguar, to his son, and he left $80,000 in cash to his daughter. I said, don't do it. Let the kids work it out. The son, if he wants the car, he'll take it and the daughter will get... No, I want the specific gift in. I said, but the problem with specific gifts is that you might well sell or lose the asset before you die. You could get Alzheimer's, and the first thing they do when you get Alzheimer's, the kids sell all your cars, your properties, your shares. They make the life a lot easier and just come back to cash at bank, and the financial advisor will be there to help you on that. No, I'm never going to sell the car. I said, well, at least let me get the specific gift, so if the car's sold and then he says, it's too complicated, Brett, just leave $80,000 to the girl and $80,000 car, the Jaguar, to my son. And he did so. He died 3 years later. He had sold the Jaguar. He'd sold the Jaguar. I don't know why, no one could ever tell me, but he sold that car. $80,000 went to his daughter and no equivalent gift went to his son. Now, I know everything went 50-50 after that, but the daughter still got an extra equivalent of 40 grand over what her brother got. I went out to their home. I went out to the daughter's home. I sat down with them at the kitchen table and I explained that I'd made the dad's will and the dad wanted to be equal, the Jaguar, $80,000. Her husband put his hand on my shoulder and said, Dr. Davies, would love to give back some of that money, but the school fees are so high, we need every single cent in order to make sure we're looking after our children. That was it. I don't like specific gifts. Now the next thing, and the hints are here and they'll take you through those things, but there's something I want to, in particular, want to tell you. And it's to do with life estates. Now what happens is that they're a disaster. They're a disaster from morally, they're a disaster, and they're a disaster from a tax perspective. And we'll go through all of that. They sound really good on paper. When I die, I want my second wife to be allowed to live in the house until the day she dies. Gives her that security. Or I've got one son, he stayed home, he looked after me. Those other kids got out and got married and had children, but my one child stayed. I'm going to do the right thing by that child. I've got no problem with benefiting those two people. But don't give them a life estate. The poor, you die and your toy boy husband or lover now sits there in this big old decaying home. He can't look after it. He gets a bit in dementia himself or gets a bit frail. He wants to go on a holiday. He can't because all his money's sitting in the house. You never gave him any money. You gave him this old house. Now he gets sick and needs to go to a retirement home. So he abandons that big house and goes to the retirement home. But it's a cheap and nasty retirement home because you never left him any money. So he's stuck there for the next 30 years living in some cheap, horrible retirement home, and then he dies. The remaining persons, the remainder persons that get the house arrive there. It's just a shambling mess of 30 years wasted, land tax being paid on it. It was better to have given your second spouse or your child some extra money or an increase of the percentage. So maybe give them 60% of the assets and give 40% to the other child. If you've got 3 kids, give the favoured child 50% and only 25%. They don't want the house. Even if they are going to live in somewhere, they probably won't want that house. Give them the cash so they can actually go buy a swanky apartment. Don't lock them into some old monstrosity of an asset called a family home. You will not be doing them any service. So life estates are very dangerous. Also from a tax perspective. So mum and dad die. My alcoholic brother gets a life estate to live in the home to the day he dies. Because he's got to have a place to live. That fallacious argument, ridiculous argument. My brother being an alcoholic, he's 30 years of age, so there's a cost-benefit calculation done. The property's worth $1 million. His life estate's worth $600,000. My interest is remain a person with $400,000 because on the actuary scale, he'll live for many, many years to come. But being an alcoholic, which is not counted in the actuary scale, he dies next year. I am deemed to have acquired a $1 million property, which is not principal place of residency exempt anymore, because I wasn't living in it. I'm deemed to have acquired a $1 million property for $400,000. And I sell it immediately. My capital gain is $600,000. Thanks, Mum and Dad. All you did was leave me a mess. Better to have put that money into let me help look after that money as my brother, as the brother, drip feed in the right amount of money, let him live in a swanky apartment, do whatever he needs to do. Don't lock people into life estates. But if you do want to put in a life estate, after all that, the clients do want to put a life estate, then, and there's the article, look at this hot second husband. 82-year-old Mavis finds a 48-year-old toy boy in a bridge club. He is not bright, he is not wealthy, but he is a lot of fun and he's as handsome as sin. Mavis, in her will, gives a life estate to this young fellow. Maybe they got married, maybe they don't. It doesn't matter. Mavis dies and the toy boy is now stuck in a big house. He can't sell it, he can't maintain it. He suffers a stroke and moves into a cheap retirement home because all the wealth's in the family home. Because he has no money, the house is left derelict. Now, the difference between a right to reside and a life estate. The life estate is you give a life estate. You can register that over the titles office and you can even sell a life estate. We're not worth that much money because when you die, the life estate dies with you. We don't know when you're going to die. A right to reside is something weaker than a life estate, and all it is your right to live in that particular property until you get sick or until you leave it for 6 months. On a life estate, you can rent it out to a third party. If the life tenant can rent it out to a third party. With a right to reside, you have to live in it. And if you move out, you lose the right to reside. Now, if your clients do want to do that, then there's the wording for it. Copy that in. I'm going to press copy. We're going to press yes, type it, then put that information in. Oh well, if I had copied it, it would have got in. determined to copy it now. Copy. Paste. There it is. So I just insert the name of the toy boy and the address, and I've got it then. I put the name there as well. So I've got a life estate. You can do a specific gift, but I don't want to. I think it's just a disaster. You can do it, but I don't think it's the right thing. Now, if you do want to give cash amounts, there's the wording to use as well if your clients want to do that. In this instance, we're going to press no specific gifts. Now, here's an interesting question. Why is there only one specific gift? Shouldn't there be one for mum's will and one for dad's will? No, you've got a fundamental misunderstanding of mutual wills if you believe that. Everything's been left to each other. Mum lives with dad. Then only when dad died does a specific gift take place. So dad's either got all of mum's money or mum's either got all of dad's money. So it only gets done once in one of the wills. Well, because that's how mutual wills operate. So I'll press no. Now we're going to move to residuary beneficiaries. Well, what's the difference between a residuary beneficiary and a specific gift or specific beneficiaries? Specific gifts are the car, right to reside, cash and things like that. Whatever's left goes equally to your 5 children, 20% each. Those 5 children are residuary beneficiaries. And this is them here. Now in my case, I've got 2 children and I'm going to make them the residuary beneficiaries. Bus, and I'm leaving it 50%. And I've got to don't forget to put the percentage sign in. It says, please enter the percentage sign. This must equal 100%. Well, that's pretty much, gee, you need a hint for that? Yes, we do, because a lot of people don't do it. And they have to go back. We'll check it. When we get to the summary page, we'll check to make sure it is, and you just go back and fix it. My spouse gets everything first. That's right. We've already done that. Your spouse is getting everything. These are the residuary beneficiaries are now after both of you, the husband and wife, have died. Well, Brett, how do you work out who gets what asset? I've got a beautiful table here. The daughter wants it, the son wants it. Well, take it to the auction. The children will just take it to the auction and auction it off. They have to work it out themselves. What about the jewellery? Leave a wish list if you wish. Don't sign it. Just handwrite your name at the end of the wish list. Leave a wish list. But the girl's going to take it. The boy doesn't want your jewellery. And the girl's probably going to take it, just take it down and melt it down for gold anyway. Oh, they won't do that. I'll tell you one reason you should make your clients do a wish list to explain why the jewellery is important and where they got it from. That way, the children are more likely to keep the jewellery. What happens if the child dies before me? There is a bloodline gifting provision in this will, so that the gifting is down the bloodline. So if my son dies and has children, then whatever my son would have got will go to his children equally at the age of majority I set, which I think was 21. If my son and his 3 children die in the same car accident before my wife and I die, then whatever he would have got will go to my remaining child, my daughter. So it's bloodline. So it goes to my son, then my children's son's children, and down the line. But if that whole family gets wiped out, then it goes to my daughter. If you have 5 children, 1 dies, it goes to the other 4, unless the dead child had children, it goes to those children. That's how the will was automatically drafted. You want to benefit your grandchildren? Then you can do that as well if you want to. You want to benefit a charity? That's fine. So for example, Red Cross Foundation, just put them in and just keep pressing add residuary beneficiaries and you can just keep putting them in. So if you want to put a charity in there, normally you just leave it all to the kids, but if you want to bypass the children, just leave part of it to a charity. You just keep adding residuary beneficiaries there, charities, grandchildren, your children, whatever you want to do. Most mum and dads would just leave everything to the children equally, which is what we're doing here. Now Colin was fine, he was of sound mind, and he is going to get his 50%. But now we've got an issue with Muriel. She is smart as a tack, she's a doctor, went through university. Middle name, didn't she? May. There we go. But she suffers from a mental disorder where occasionally, and it's happened in the past, occasionally she becomes a spendthrift through a mental disorder. She's still still the executor with my son for my wife and I's will. I'm happy with that. She's in control most of the time, but she can't get the money because I'm going to type in here 50%. But she can't get the money carte blanche under her control until she's 99 years of age, which means the money will stay in the trust to be administered by two people, the two executors, one of which is her, one of which is Muriel, but the other's a brother. They must act unanimously. They must act together. So while Muriel's of sound mind, they will together just pay debts and do things, buy properties. Muriel will go on trips, do whatever she wants to do, provide money to her children, provide money to her husband, whatever she wants to do. But if she does become a spendthrift, she can't get that money. She can't get those assets. They're protected because both her brother and her have to sign. That's how you deal with that situation. If you need a hand with that, just telephone us up, speak to one of my lawyers or speak to me. There's the hint there. And yet, another bit of information there. Future unborn children, just email us the voucher and we'll send you out a new voucher to do the wills, again for your clients at no charge. So 99 years of age for young Muriel. Oops, sorry, that's the wrong one. No, but that's my boy. There it is. 99 for the girl. And again, when you come to the very last page, the summary page, we'll have a chance to have a look at every single question we've answered and we can go through everything and check it all. And if also you've made a spelling error or an address or something like that, just email us back and we will give you a voucher to do the document again for free. Never fear. And also if the clients just don't want the document anymore, then they can just email us back for a full refund. You don't have to use that address line one. You can actually fill out the addresses manually if you want to. Just that, kind of like that facility on our website. Now, a disaster clause. What a name! What a name! A disaster clause. It says it all. This is only useful if your client's children are still young and they're still travelling together. So I don't know about you, but the children seem to not want to be with their parents. Don't want to be with their parents when they reach a certain age, whether that be 16 or 21, I don't know, but they were no longer travelling with the parents. You don't need this clause. So the children are all in their all 18. You probably don't need the clause. It's just that if you're in an aeroplane with you and your spouse and your 3 children, the aeroplane goes down, then you need the disaster clause. Now what you've got to do here in that situation is your family's wiped out. You'll probably leave half the assets to your spouse's, to your wife's children, to your wife's parents or brothers and sisters, and the other half will go to either your parents or your brothers and sisters. Now remember, you've got either all your assets and your spouse's assets, or your wife's got all the assets, including your assets. So you've got to have the wills mutual. They're going to each other, and they're going to be split 50-50. So your kids are all dead, the grandchildren never born. So 50% of the fortune or the wealth of your husband and wife will now go half to her side of the family and half to his side of the family. Pretty straightforward. So in that instance, you would press yes, and you would put in, let's say, Dad's name, 25%. You then do another one, put Mum's name in, 25%. Then you put your wife's Mum and Dad in each. So there'll be 4 of them there. And if Dad was to die, it will go to Mum. And if Mum and Dad are dead, it just goes to your brothers and sisters. But in this instance, my children are all over 18. I don't need to worry about that clause. So I won't put a disaster clause in. Now the next two, 99% of times you're going to answer no to both contemplation of marriage and contemplation of divorce. Normally, very rarely do we do it. How often, Natalie, would we do that clause? 1% of the time? If that? Yeah, even if that. So this is only if you are in a de facto relationship. So let's have a look at this. You've been in a de facto relationship, your client has been in a de facto relationship for 20 years, they're never going to get married. Maybe they're a same-sex couple or they're just heterosexual, but they don't want to get married. That's fine. But if they do get married, in the future, the will is revoked. Both wills are no longer valid. So let's think ahead. You've got to have this conversation. Say, look, if you do get married, do you want your will to still be valid? Oh, yes, we do. Well, in this case, let's press yes. So you will put in your spouse's name, Muriel. I can't remember my wife's name, but anyway, you'd put in your wife's name, and you would also press her. Then you'd put in your name as well. So that would then go in. But that's only if they're not married. Now, in my situation, I'm married. So I'd press no. Like everyone else, I'd press no to this question. It's only if a couple living in a de facto relationship, and it's only if you know who you're going to get married. Now, there's a single person out there, you don't know who you're going to get married to, you can't fill this out. You've got to actually name the person you're going to get married to. If you don't know, you press no, and your will be invalid when you get married. But don't worry, just get your accountant or financial advisor, email the tax invoice back, we'll give you a new voucher to do a new will. Because there's 100% money back guarantee forever on all our documents. So contemplation of marriage is normally no. Contemplation of divorce is even less likely to be used because it's only if you are getting a divorce. Well, when would that be? So let's say, for example, you were married 20 years ago. You haven't seen your spouse for 20 years. So you shacked up with a new person and you've been living with them for 20 years. Well, it's possible that you might get divorced in the future from your previous spouse from 20 years ago. If you do, the will's invalid. So in that instance, I was married to someone many, many years ago. And I will put her name in. And that means that if I do get divorced from May June Smith, the will remains valid. If I don't divorce May June Smith, the will's still valid. The will's always valid. So always think long and hard about if one of your clients would ever divorce. And there it is there. Plenty of training. There's another training video there. And the question is offensive. I'm a good Christian. We don't believe in divorce. Well, that's fine. Just press no then. And obviously, if you're happily married to someone, you're happily married to your partner, you press no. You're not going to divorce your partner. And if you are, you probably want to redo your will anyway. So the answer is pretty much always no. Now, guardians are when you have children under 16, if not it says 18 here, because at 16 in most jurisdictions the children can leave home by themselves, which just seems extraordinary, a 16-year-old leaving home. But they can, and therefore they may not be bound by the guardianship clause because they can just leave home anyway. I still think it's a good idea to put it in your will. Now with guardianship, you can either do it by way of deed, which is like a document, or you can do it under a will. It's better to do it under a will in my view. If you have children under 18, I think you should take the option of doing a guardianship clause. Some people say they're not worth it because they can be overridden by the local state government, the family courts and what have you. True, but that's very rare. And I've never seen that happen to one of our clients. So you should take the option of having a guardianship clause. Putting in, so if you have no children under 18, you press next. This is just some more arguments here to say why you should do guardianship clause. Why is it only suggesting? Because the courts can override it. More than one guardian, yes. So if you're a young couple, you may decide to appoint all four of the parents, your wife's parents and your parents, so all four of your guardians. Remember, the guardian is not necessarily the person looking after the children. That may not have day-to-day custody. It might be someone else. But the 4 grandparents of the children will make that decision. So you press yes. And in this instance, you might press 4 guardians. So you press that 3 more times. But in this instance, my children are over 18. I don't want to take up the clause. So I'm going to press no. I've got a green tick. Gee, I'm doing well. Look at those green ticks. Now, it challenges the will. The people that can challenge your will are 4 groups. Your parents, or particularly when the parents are living with you. Okay, it's very rare. People you sleep with, like a wife, a husband, same-sex partner, de facto relationships. And under Australian law, you can have all 3. Bigamy is alive and well in Australia. You can have a mistress, a wife, and a gay partner, if you can afford it. The next group down is your children, children you adopt, and stepchildren that you're maintaining in most jurisdictions. And the 4th group are your grandchildren, but generally only if the parent is dead or the grandchild's living with you. There's also notional estates where that can be broadened further. Give me a ring if the clients need a hand with that. Now, if I'm worried about someone challenging a will, let's say I've cut one of the children out, then you should put the name of that child here. So and I'm only going to put it in my will because it's my son from my first relationship. His name is Mark. Crasto. So I've decided to name. Now, with the challenging a will, Mark may well challenge the will. And what I want to do, I don't need to do it for my spouse because she's only got 2 children. She's living with the 2 children. I've actually had a child from a first relationship. I'm cutting him out. So I'm going to press yes for me, for Thomas. Will someone be upset? There's a training video there as well. Now, and some people say, just leave $1,000 to Mark. Wrong. If you leave $1 or a token amount to that particular beneficiary, all you've done is turn them into a beneficiary, so now they have more rights than what they had to begin with. A considered person clause is a superior way of doing it. Don't leave a token amount of $1,000 to someone or $1 or whatever. Leave $50,000, that's not token, but to leave $1,000 or a small amount of money does not help or aid your cause in that child challenging the will or that beneficiary challenging the will. All it does is make them a beneficiary and gives them rights. The considered person clause is pretty, it doesn't say anything mean or anything. It just says, it's used from, we take the wording from a court case. It just says that I've given thought to Mark Krasco, and I feel I've given him enough throughout his lifetime. Pretty benign. It doesn't say anything mean or anything. If you do have a story to tell about why Mark is a very evil and horrible person, then certainly get your client to write that in a letter, but don't put it in a will, because the will becomes a public document. The will can be checked by, or can be looked at by Channel 7 news crew. It's open, it's public, and you don't want that. The Australian Taxation Office can get a copy of your will. Don't tell anything like that in your will. So now we can do a reference. Now, I'm an accountant, and I'm going to put my reference in, BKD, Brett Kenneth Davies. My supervisor was Natalie Connor. My client reference was that, and the matter number was that. And I could put in the name of the Combus if I wanted to. Look, I won't do that. I'll just leave it like that. Now, I can now search on that. In 20 years' time, I can go back and search on the references. I can also put that on every single page of the will. In this instance, I'm not going to. And I'd also like to put my accounting house logo on, because I uploaded it in your document some time ago. Right, now we're going to go to the summary. This is every bit of data we put in. Now, if I was to leave this and go pick it up tomorrow, all the data is kept and stored. It's all there it's there for infinity. So let's have a look. Thomas James, Mary Smith, that's good. Residuary beneficiary, yes, that's all correct. I'm happy with that. I'm now going to lock and build. Now, I'm going to put in my credit card details. So I've put my credit card details in, and now I've got myself my document. So I can update my profile. I don't want to do that. I want to see the document I've just built. I'm very excited. So this is what we've got here. So the document is stored on our website. You can log in 30 years' time and bring it up. The document's also emailed to the email address you've got. And there it is. Mutual will, just what I've just built. There's my reference number on it as well. So let's have a look at this. I'm going to open up the PDF. Congratulations, you've built yourself a 3-generational testamentary trust. And let's have a look how we're going. It's now on my hard drive. I can email it to the client. I can print it off, do whatever I want to do. My logo would have been there if I had put my logo in. And there's my reference number there. This is really good. So let's go through the will. Clause 1. All previous wills have now been destroyed by the act of me signing this will. You don't need to find them. If you can, tear them up. Otherwise, they are now no longer valid. What I've done first is I've appointed my spouse, Mary Davies, as my executor. She's going to do the same in her will a little bit later on. Provided to survive each other by 28 days. Now, why have I put that there? What happens is that under Australian law, if you die at the same time as your spouse, like in an aeroplane, then the older in time is deemed to die first, which means that I'm older than my wife. All my assets now go to her, and she now gets the assets to the children. What we want is, we don't want that, because every time there's movement of wealth, there's capital gains tax, stamp duty, income tax, and superannuation issues. So we don't want that. Therefore, we put a 28-day clause in. It means you have to live each other by 28 days. And the backup executors are, after my wife and I, perhaps my wife is too frail or unable or unwilling to do it, just gone too frail or has died, then we've got the 2 children, Colin and Mary. Now, Mary is suffering from a mental disorder, but it's not sufficient to stop me from making her the executor. In fact, it's good to have her involved. The definitions themselves don't mean much. There's the age of majority of 21 years of age. I'm not that interested in the definitions. I'll come back to them if we need to. The next thing is, we've got a couple of suggestions in the will. The first is that the executor obtains advice from their lawyer, accountant, financial planner. It is critical because there's so many tax-saving mechanisms there are so many tax-saving mechanisms in this will. You've got to have your lawyer, accountant, and financial planner present, but predominantly your accountant, financial planner. The second suggestion is that all the debts of the estate be paid first. And this is because under Australian law, each executor is 100% liable out of their own pocket up to the value of the estate for all debts. Knock on the door. Your dad owed me $500,000. Oh, that's fine. I'm getting half the money in the estate. Here's $250,000, and go see my sisters for the rest. No, I want the $500,000 from you, and then good luck for you to go off to England, where your sister's now living, to get the other $250,000. And that's why your children, they don't have to, but that's why your children should pay their debts first. The next thing we're doing now, if my spouse survives for 28 days, I give the trust fund to my wife. But what if she doesn't survive me by 28 days? Then we give everything equal to Colin and Muriel. But what's this age of 99? Well, that means that the money's held in trust until the child turns 99 years of age. It is administered by Colin and Muriel together. Colin's got his 50%, he's gone. He's either formed 0, 1, 2 or more testamentary trust for his 50% of the estate, and he's gone. With Muriel and Colin look after the money together, acting unanimously. Clause 5 deals with that bloodline gifting, so that if a primary beneficiary, such as Muriel, dies, then what Muriel would have got will go to her children at that age of majority, which is 21 years of age in this particular will. So everything to each other, everything to the children equally under this will, and then to the children's children if one of the children's dead. Clause 6. While my daughter is under the age of majority, which for her is 99, which is going to be all throughout her life, the money can still be used, the wealth, there's still investments and things that my son and my daughter together will do. The money can still be used for maintenance, education, advancement, support and benefit. And this is not just toilet paper, buying toilet paper or a Coles or Woolworths shop. This could be car to get to university with. It could be a holiday. It could be a wedding dress. It could be anything, provided the two executors feel it's in that daughter's best interest. So we're not being draconian about it. We're just merely letting her use the money under the control of a brother. So if in that unlikely event she becomes, well, in the likely event over the next 3 or 4 years she becomes a spendthrift because she suffers from that type of mental disorder, she's protected. Now, if, for example, my daughter was an alcoholic, then what can happen is my son, and this is the real life situation, my son may say, look, sis, if you have no alcohol in your blood for the next 12 months, I'm going to give you $150,000 to use as you see fit. And you do it again for 5 years, I'll give you the rest of the estate. Because I want to motivate you not to be an alcoholic. Drugs and things like that, it's a very useful mechanism to protect your children. Now, Clause 7 deals with the executor's powers. And these are the powers. Remember, the Testamentary Trust can go from the date of your death, from the date of your client's death, for up to 80 years. Now, we had a client, they did their wills in 1994. They died in 1997 together, and they're leaving behind 3 children. We still act for 2 of the children, and they came in with their accountants and financial advisor. The average income that estate it generates each year is roughly around $70,000 a year. The 2 children we act for, one's a medical doctor and one is a plumber. The plumber actually makes more than the medical doctor, which I found quite fascinating. But they're both on the highest marginal tax rate. Even with that, the income tax they've paid since 1997 each year has been 0. Not 1 cent of that $70,000 to those 3 children has any income tax been paid off. And on top of that, when the parents died, the children were over 18. They should have suffered the 17 or 32% tax on their super. Because there was superannuation testamentary trust in their will, not 1 cent of tax was payable on their super. They got 100% of the super from mum and dad paid out 100%. Brilliant. And that's the benefit of flexibility, 3-generational testamentary trust, superannuation testamentary trust. So the executor's powers, they go on and on. They need to go on, about to run businesses. Clause 8 protects the integrity of the document. So if a law changes, such as trust laws, the gifting provisions to the children and do the children's children become paramount. So everything is read down to protect it. So even though your client may never want to update their will ever again, the gifting provisions will always remain paramount. You should be reviewing your wills with your clients every 4 years or so. Superannuation Testamentary Trust deals with washing out the 17 or 32% tax. And in this will, it's got a considered person clause. We're going to look at the wife's will in a minute. That won't have a considered person clause. And here it is. I consider my obligation towards Mark of student university in Cardennia, Western Australia. I expressly declare myself completely satisfied all proper provisions being made for Mark. Very benign, not scary or threatening. If there is a big story to tell, don't put it in the will. The will is a public document. Put it in a covering letter. The will is signed with 3 blue pens. 3 or 4 blue pens, all identical in a room. You and the 2 clients are in the room with 2 strangers, someone you like, 2 accountants or your secretary and yourself. You lock the door so none of you can leave throughout the signing of the will process. So none of you can leave. You have to be strangers. You can't be related to. If they've got a girlfriend of someone related to them, you can't do it. No relations whatsoever. They've got to be next door neighbours or your accountant or your financial advisor or your lawyer witnessing the documents. So that's his will. And here's her will. Here's Mary Davies' will. And you see it's couched as a mirror will, so everything's going to each other. There it is there. And everything going to the children equally. And it's under the same terms of what the other will said, except here there's no considered person clause because Mary's, my first child can't challenge my wife's will. And there it is. There's the covering letter addressed to your client confirming we are the lawyers that prepared this document. Not the accountant, not the lawyer, not the financial advisor. Our law firm prepared the document. So we carry all the professional indemnity insurance. And what does the letter say? Well, it says, firstly, find 2 people that are over 18 years of age, of sound mind, and have an address in Australia. Better to have addresses in Australia. If they're going to sign offshore, you can still do that, but give me a ring and I can help guide them on that. The witnesses can't be related to you or have any chance of being related to you. It can't be your son's girlfriend because you could marry that person. All beneficiaries and potential beneficiaries leave the room. Get 2 witnesses and yourself in a room with at least 2 identical blue pens. Lock all doors. It's all there for you. Sign in the same blue pen. Blue pen's better because it's harder to photocopy. The photocopier is so good these days that the probate office generally has to work out whether it's an original or not. Make it blue pen. Although these days colour printers are getting better as well. Date the will. If you need reading glasses, don't sign the will until it's done. Storing wills. The wills should be kept in a safe place, generally at home. Let the executors know where they are. Superannuation, so some advice to the accountant advisor. More information on superannuation, finding nominations, reversionary pensions. Reversionary pensions are big issues now, and only financial advisors give advice on reversionary pensions. So speak to them about reversionary pensions, a wonderful thing, but a much more complex. Now we've got the $1.6 million rules. Have life insurance. The life insurance should be payable like the super into the will. The superannuation does not automatically go into the estate. Superannuation at death, because you can't keep super after you die, has to go either directly to a dependent or into your will. Don't leave it directly to the dependents, put it into the will, because then the Superannuation Testamentary Trust can wash out the 17 or 32% tax. Even if you die and you're giving it to your wife gets it tax-free either way, either directly to her or into the will. But if the super goes into the will, potentially the income generated over the next 80 years of that super, let's say you die with $1 million worth of super, your wife gets it in the will, let's say it's earning $80,000 a year, often that $80,000 is income tax-free each year because it's in the will. But if it's in her own name, then she's got to add that $80,000 to a tax return and pay tax on it. So it's better under all circumstances to leave the super into the will. The only time you wouldn't want to do that is if someone was going to challenge the will. So In my case, I don't have a mistress because my wife won't let me, and therefore I've got no probability of the will being challenged because I'm leaving everything to my wife, everything to the kids equally. Under that situation, under this situation, I've got another child, but if I didn't have that other child, I'd have no risk. Who can challenge the will? Lots of information here. Now, get a doctor's to note to say you're of sound mind. I don't care if you're 25 years of age and you've never touched drugs, you don't even drink alcohol, you don't even drink coffee. I still want you to get a doctor's certificate. And here's the wording. I've today examined Thomas James, Mary Davies, obviously they're separate. You need 2 certificates. I believe that this person has the ability to understand the nature of a will. All these years, I've never found a doctor just to follow what I say. They write their own thing, and that's fine. But just get a doctor's certificate and keep that doctor's certificate, the 2 of them in this case, because they're mutual wills, you've got 2 wills, keep both those doctor's certificates in with the wills. Signed by the law firm. Wonderful. So you have over the last from the beginning of this training video, learned how to prepare an estate planning document. You can come back to that will 20 years later, and now you want to go ahead and build powers of attorneys and medical powers of attorneys, powers of guardian, and have those 3 separate documents for your client. So you'll need your 2 powers of attorneys, one to dad, one to mum, and you need 2 medical powers of attorneys, and you've got your 2 wills here. Telephone us anytime. We're happy to give advice. Remember, we're a law firm, and that's the additional advantage you've got in dealing directly with a law firm. Professional indemnity insurance. Everything on the website is controlled by our law firm. The logic flow, the questions, the answers, the hints, the training videos. They're all lawyers. We're all lawyers here. You get legal professional privilege, which means the clients get legal professional privilege, which means that this information is kept confidential and only your clients, the clients are protected over and above what they would normally be protected as. You also get a covering letter from us, signed by a partner of our law firm, and 100% money back guarantee. You return any of the documents anytime for a full refund. So enjoy the advantages of dealing directly with a law firm, and telephone any of my lawyers or myself if you need a hand with estate planning for your clients. All the best.